Yu, who is with the Contra Costa County Bar Association Real Estate Section. Angela?
Thank you, Anne. Welcome all to the Real Estate Section's monthly MCLE program. I am, as Anne said, Angela Yu, and as the section's current program chair, I have the honor of introducing our speaker today, Fernando Villa. Fernando is a partner at Allen Matkins. His practice focuses on land use, environmental law, local government matters, and real estate dispute resolution. In particular, Fernando represents clients in land use entitlement, CEQA, and local government law matters involving a broad scope of entitlements for a variety of development projects, including mixed use, industrial, residential, retail, master planned, and commercial developments. A former litigator and a former city attorney and special counsel to cities and other public agencies, Fernando brings deep and singular experience and perspective on diverse facets of real estate law. Although he is currently resident in Allen Matkins's Los Angeles offices, Fernando does have Bay Area roots, and I have it on good authority that he remains a loyal Cal Bear. With that, I will turn things over to Fernando Villa.
Thank you very much, Angela, and thank you all for coming to today's event. Angela, you made me feel a lot more important than I should, so thank you very much for that very kind introduction. As Angela mentioned, I'm about to share my screen here in a moment here, and let's see if I can do this right. Here we go. Hopefully you can see my screen now. But as Angela mentioned, my presentation today will focus on the sort of how and means by which you can use various tools that California law has provided for developing affordable housing and still make a development project pencil for your clients, making it very economically feasible, streamlining the entitlement process, providing incentives and entitlements effectively without having to go through the normal level of risk that entitlement process would entail. And again, all designed to incentivize private developers and the investment community to invest in affordable housing. So with that, I'm going to move to my next screen here. The agenda is very straightforward. We'll go over at a high level, and most of my conversation today, by the way, I should mention at the outset, will be high level. I will try to illustrate as and when I think it makes sense to do so you can see how these tools can be used. And I encourage you, if you have any questions as I make my presentation, please jot them down, and Angela will share them with me. I'm happy to answer any and all your questions at the end of my presentation. So with that, the agenda today will focus on what I loosely call the DBL, the California's density bonus law, how to use that law to the advantage of your clients. SB 330, which is an interesting sort of a twist on what the tools are now and how you can facilitate, accelerate the agency's review and approval of your client's projects. Vested rights, both under the common law, the tract map process, and the development agreements. Very innovative way to get to where your clients really want to be, which is to vest your rights at the outset of the entitlement process, lock in those rights for periods of time, and gain other advantages, but also bearing certain burdens that you should be aware of if and when you decide that's an appropriate tool for your clients to utilize. So let's start then with the DBL, the density bonus law. This was enacted in 1979 at a time when California then, and even more so now, was experiencing a major housing crisis of affordability. The demand for housing in California was then and continues to be, and actually has only grown, believe it or not, even during the pandemic, exponentially, where demand far exceeds supply. And with that, the demand, especially for affordable housing, has gotten enormously out of control in California, in huge measure because real estate values, as we all know, have gotten really, really out of hand. There's a law called the Housing Accountability Act, just to illustrate the point, that allocates through various regional agencies responsibility to each city to project and fulfill designated numbers of residential units in their various territories based upon projected demographic growth. And I can tell you virtually every city, certainly along the coast of California, is woefully behind those projections, and in many other parts of California. So this is a very real problem that we're all trying to grapple with. So the density bonus law is intended to incentivize developers to construct below market affordable housing. The below market rate units must be provided either on site or via land dedication offsite. The type, and I should say the amount of your density bonus really depends upon the various percentages of units that you allocate, both based on income and numerical number of units. And we'll get into that in just a moment. Interestingly and impressively, as of January 1st, 2021, the maximum density bonus went up from 35% of what would otherwise be permitted under the applicable city's codes to 50%. Obviously, that entails a fairly significant allocation of affordable housing units, but it is a very substantial increase, again, in recognition of the need and demand for affordable housing. There are other benefits that the DBL provides. We'll get into those in just a minute, but they principally come in the form of what are, besides the density bonus, of course, which is a huge benefit to developers who look for density, who want to be able to have their pro formas perform and have a great return on investment. That usually means a lot of density. But there are also advantages in terms of providing what are called incentives and waivers of development standards, which we'll discuss in just a moment. Oops, sorry, skipped over the next slide, which is basically the big picture, high-level review of what the allocations are. So, for example, before 2021, and we'll get into what's in effect now in a short while, the very low income, each of these, by the way, income levels are based upon locally determined area median income levels. But very low income, if you set aside 11% of your allowable units in the current code requirements, you get a 35% add on to the density that you can have for your class development project. Low income, same thing, except that it requires, because it's a higher income category, a higher set aside. Here it's 20% to reach the 35% maximum. And you see moderate income, an increase in the number of units allocated to achieve the same 35% limit. Going now to AB 2345, this is the law that I mentioned that went into effect January 1st of this year. We now see a concomitant increase for these different categories, all the way up to 15% based upon the various percentage allocations that you see here on this table. So what does that mean? It means that if the developer offers to set aside the requisite percentage of units, whatever those income levels are, the local government has to, whether it's a city or county or other local agency, the city has an obligation to provide that density to the developer. This is not a discretionary action by the city. The city must provide this entitlement to the developer. The other consideration, though, is that what goes with that density bonus are what are called incentives or concessions, right? And these are essentially other protections, basically a reduction or a relaxation or adjustment of development standards or modification of zoning or architectural design requirements that would otherwise stand in the way to achieve the project's goals. So, for example, the standard, I should say, for granting an incentive or concession is that incentive must result in an identifiable and actual cost reduction that would provide for affordable housing costs. Now, the way the statute's worded, it's rather interestingly presented in the statute. It seems as though it's the developer's burden to make that demonstration, and in name it certainly is. But in actuality and in practice, what that means is the way the law is set up is the city cannot deny the developer an incentive or a concession of the developer's choice, by the way, not the city's choice, unless the city can demonstrate by substantial evidence in the record that the incentive will not result in identifiable and actual cost reductions. And typically that's very difficult for cities to do. It's a finding that's difficult to achieve because typically the developer has done its homework and has shown that, look, city, here's my pro forma, and I'm telling you, I really need this incentive, be it an increase in height, for example, a relaxation of setback requirements, a reduction in parking requirements, and so on. I need these incentives to achieve the design and density for me to allow the kind of return on investment that will make the set aside of these units that otherwise could generate far greater rents or purchase sales to make this work. So typically the cities have a hard time sort of overcoming that standard of proof. Okay, so what are some of the incentives? I mentioned the reduction in development standards. They can also include mixed-use housing. Let's say the current city zoning does not allow mixed-use housing. It's only residential. Well, guess what? One of the incentives that you can pick and choose in the state density bonus law is to make your project a mixed-use. For example, you may want a commercial retail. You may want a 50,000 square foot a wholesale food store that will generate a ton of revenue, sales tax revenue, and other revenue for for the developer that retains ownership of that commercial space, and could be very, very profitable. Other regulatory incentives could also be chosen. The city, by the way, does not determine the incentives, the developer does. Whatever the development standard is that the city needs, I'm sorry, that the developer needs to be relaxed, it's up to the developer to choose that. The flip side of these incentives is that, the last bullet point here, is that the agency, the city, cannot apply any development standard that would physically prevent the developer from building the project with the density bonus and the incentives to which that developer is entitled. So, for example, let's say the developer says to the city, hey, I want, I'm setting aside 35% of my units for very low income. I'm entitled to two incentives, and I want my incentives to be height, and I want my incentives to be setback. So I want a relaxation. I can build, within 5 feet of the boundary versus the 15 that your setback requirements require. And I want to build to 110 stories versus, 110 feet, that the height limit of 80 feet would otherwise not limit me. And oh, by the way, you can't apply development standard of stories. I'm now going to go from 8 to 10 stories. You can't apply that development standard, because if you apply that standard to me, you will prevent me from developing my project as I've designed it for 110 feet with the setback requirement. If you apply that story limit, I can't go to 110 feet. So in that event, the city is precluded from doing so. That typically comes in the form of a waiver, which we'll get into right in just a minute, I should say. Oops, sorry about that. Went the wrong way. Give me a second here. I'm not the most dexterous person in the world. Here we go. So I mentioned incentives and concessions. So here are the incentives that the developer could be entitled to, depending upon the quantum of set aside units, depending on the income level. So, so here we have, if you set aside 5% of your units for very low income, you're entitled to 1 incentive. And so on down the line, you see that allocation increases based upon higher income levels, and so on, all the way up to 3 incentives, where you set aside 15% of your units for very low income. And now you have, in the case of low income, the statute relaxed the standards that came into effect January 1st, again, to encourage, to incentivize affordable housing. You no longer have to set aside 30% of your low income units to qualify, for example, to qualify for 3 incentives. Likewise, for 2 incentives, you go from 20% to 17% allocation of low-income units. All right. So what are the state mandated parking benefits under the state law? As we all know, different cities have different parking requirements, but oftentimes those parking requirements really add a ton of costs, especially, for example, if the developer has to go subterranean, that tends to increase costs hugely. So the state law, the state density bonus law, in recognition of how parking requirements can really make projects uneconomical, the state provides a uniform standard that the city must follow, regardless of what its local parking requirements are. So you'll see, for example, if you're having the spaces required, if it's a studio or 1 bedroom, it's 1 space. If it's 2 bedrooms or 3 bedrooms, it's 1.5 spaces, and 4 bedrooms, it's 2.5 spaces. Typically, city standards are much higher than that. Once you start going from 1 bedroom or studio to 2 or 3 bedrooms or more, you'll see many cities will require, for say, a 2-bedroom place, either 2 or 3 spaces, and so on. So this is a huge, huge benefit, and can really greatly reduce the parking on site that the city would otherwise be entitled to require. So we talked about the recent amendments that came into effect January 1st. Interestingly and very nicely, among other things, now this new law provides that governments can add additional waivers or reductions if they so choose, for development standards for projects, what I will loosely call TODs, transit-oriented developments. These are projects that are located within 1/2 mile radius of a major transit stop. It can be a bus stop, it can be a rail station, light rail station. And so if that's the case, then the city can provide additional waivers or reductions if, in fact, it appears that that would help achieve affordable housing costs, as we discussed before. It also provides further reduced parking standards for eligible residential projects that provide unobstructed access to a major transit stop, or that are restricted for rental housing for senior citizens and the like. So I have a project right now that literally is across the way, walking distance, unencumbered by a street, unimpeded by any major public right of way, where literally people who get off the train station can walk to our client's mixed use residential project. And we're taking advantage of these added incentives, and it greatly reduces the costs of designing and building that project. So SB 330, this was a law that came into effect, you see January 1st, 2020. It's effective through 2025. But basically, it's a Housing Accountability Act amendments. The Housing Accountability Act is a tool that until really after the recession, the Great Recession happened, really wasn't used very, very much. But this is an impressive law for a handful of reasons we'll get into in just a minute. And one of the things I want to emphasize is oftentimes our clients will use the benefits of the Housing Accountability Act in tandem with the DBL, also in tandem with development agreements, investing tentative maps, which we'll describe in just a moment, that when taken together can really add powerful means by which you can streamline the entitlement process, add lots of density and benefits, and extend your vested rights in a way that either one of these mechanisms or without these mechanisms you could otherwise achieve. So what does this law provide? It provides that under existing law, the city could disapprove a housing project, can only disapprove a housing project that complies with applicable planning, zoning, and subdivision standards as of the day of the application. Only if the agency finds that the project would have a specific adverse effect on the public health or safety, and there's no feasible alternative method to mitigate and avoid the adverse impact. Again, there has to be a preponderance of evidence that substantiates those findings that cannot be made arbitrarily. So that this law really greatly limits the quantum of discretion that a city has to deny a housing project that otherwise is compliant with its planning, zoning, and subdivision standards, right? And especially if you're going to be providing for affordable housing. And why did the state decide to do that? It decided to do that because what was happening is that in many localities, city councilors were using their otherwise fairly broad discretion to deny residential projects, especially those that introduced affordable housing. Why? Because of the NIMBY syndrome, where so many of these, especially more affluent communities, did not want to see increased residential density, either because of traffic concerns, either because of demographic concerns. We don't want that type, that people who can't afford affordable housing. We don't necessarily want that type in our community. And so the state government said, we need to stop that abuse of local discretionary authority that land use decision-making has provided cities, so we can expand the housing footprint that California residents so badly need. Okay, and then the city also under this law must provide written and consistency determination within 30 to 60 days based upon the number of units that are provided. And interestingly, if the local government fails to respond within the time frame, the project is deemed to be consistent. So that's really, really important. Why does this law become so effective? It's because it establishes what we loosely call a vesting date. And that means that when someone applies under this act for approval, review and approval by the city, where again, the housing project complies with the planning, zoning, et cetera, regulations of the city, as of the date of filing the preliminary application is when the city can no longer pass laws, measures, moratoria, zoning changes that would restrict, impede, or otherwise make it more difficult for that housing project to be reviewed and approved, right? And we've seen that time and again in the state of California, where so many cities, when they start seeing a spate of housing development applications come through the door, whether it's initiated by citizenry or by various members of the city or the city council itself, where they start trying to curb, place more moratorium, otherwise make zone changes that would restrict where this housing can be placed. Once that application is filed, the city can still make those measures, can still enact those more restrictive measures, but they cannot apply to that project. Again, at the very filing of the application. This is long before, for example, the city council or the planning commission might actually approve the entitlement. So you've baked into your project certitude, a certainty that the city will not change the rules on you as you proceed, as you initiate and proceed with the entitlement process. That's very important too in California, because as we all know who are involved in the development business here, the entitlement process can be very, very prolonged and very high risk. Vesting include, by the way, impact fees. So for example, if the city has an impact fee, whether it's school impact fees, park impact fees, Quimby fees, park and police impact, infrastructure, traffic mitigation impact fees, a whole plethora of impact fee schedules that the cities now have, especially the larger ones across the state. Those impact fees cannot be increased. They can be increased, but they can't apply. Those increases cannot apply to a project that's been submitted under the Housing Crisis Act, right? For that's, and investing is good for 2.5 years after receiving approval. So that's a very, very important right that the developer would have in this situation. And as I mentioned, once the application is submitted, it's deemed complete. Beware though that we see this happen time and again, especially larger residential projects, multifamily projects where developers start tinkering with the design. You can tinker away under this act, but once you have a greater than 20% change in your square footage or the number of units after you filed your after you filed your preliminary application, then you've got to submit a new preliminary application, and the timing for your vesting starts all over again. So you should try advising your client, if you're going to take advantage of this law, just be aware you've got this 20% sort of envelope in which you can play and design and redesign. But once you go beyond that, you lose the benefit of that initial vesting date, and you'll have to start all over again if you do that. So anyway, so the other interesting thing is if the city is going to determine that an application is incomplete, the city has to provide very detailed items that demonstrate incomplete, and the city cannot impose, once the developer complies and provides the items that the city initially determines render that application incomplete, the agency cannot thereafter start imposing or creating new items that they have to be completed by the developer. In other words, sort of kind of moving the goalpost on the developer. The cities are prohibited from doing this under this amendment. The other interesting thing is a city or county that's affected by the project cannot change the land use or zoning of a proposed project, whether it's in a way that would make it less intensive, that would be more restrictive, for projects that were deemed complete after January 1st. That's a very important point, because that means, other agencies, if they're affected cities or counties, cannot change the laws as well. That would in any way prohibit a city from, an applicant from proceeding with the intended development. And this, by the way, this amendment only applies to projects that are deemed complete after January 1, 2020. Oops, sorry. I'm not the most dexterous person on the planet, as you can tell. Okay. Now let's segue to the realm of, and once we go over these various tools, I'm going to try to give you some examples of how you can mix and match these various devices that are at your client's disposal in a manner that, again, optimizes the highest and best uses for residential density and other purposes, and your ability to gain density, get a project design, and not let city standards stand in the way, impeding that design, and vesting your client's project for the period of time that otherwise would not be available. So common law vesting, and some of you may be aware of the so-called Avcor Rule. This is a lodestar decision that came out in 1976. And under the common law, before this decision came about, cities basically, because of their broad discretion under the police powers to effectuate zoning, land use, planning, and other measures to protect the health and welfare of its residents, had tremendous power to change the laws and change the rules that govern planning and development, even when a project is midstream in the application or the entitlement review process. And there seemed to be a fair amount of abuse that was going on back in the 70s and 60s before then. And so in the lodestar Avco decision, the California Supreme Court said, look, the cities, there has to be some, even though the cities have broad police powers, at some point in time, there will be a reasonable expectation on the part of the developer and those attached to the developer, be they investors, be they lenders, be there other stakeholders involved, prospective renters, et cetera, that come to believe that the city cannot change the rules. There's a point in time, it's a form of promissory estoppel. City, you promised that I could develop this project under this regime or under these approvals, and now you can't pull the rug underneath me. And that bright line, it really turned out to be not terribly bright, as it turns out, but that bright line was drawn by the Supreme Court saying, look, a developer has a vested right, that is, after that right is achieved, the city can no longer change the rules, can no longer restrict that development because that developer has done enough to vest that right. When the developer accomplishes the following: number one, obtains a valid building permit, And secondly, perform substantial work, and therein lies some of the grayness, right? What is substantial work? Really lies in the, really falls upon what is viewed. It lies in the eyes of the beholder. And then lastly, the developer has incurred substantial liabilities in good faith reliance on the permit. The problem with that standard, as this case itself illustrated, is that there's a lot of variability and there's a lot of discretion and judgment involved as to whether, especially the last two prongs are met. So in the case of the Avco plaintiff, it was an empty victory, or it's a Pyrrhic victory, because what ended up happening was, although the developer had built storm drains, utility improvements, it had not acquired a building permit. It spent over $2 million and incurred $750,000 in liabilities to build that infrastructure, undertaking numerous other investments, both hard and soft costs. And then in 1973, the Coastal Act required a coastal development permit because a small portion of this project was in the coastal zone. That became a problem. And then ultimately the Supreme Court ruled, although we've got this great vesting rule, it doesn't apply here. Why? Because there's no exemption to the coastal development permit under this other sister state law act. And oh, by the way, since you didn't have a building permit developer, we're not going to recognize any vested right that you have, and tough luck. But we've got this great protection now for future developers, right? Well, over time, various cases evolved that rule, refined it a bit, right? So clarity was acquired when courts have said, look, the rights that a developer vests really are no greater than what the valid building permit otherwise permits. So for example, if all you developer got was a so-called grading and demolition permit, in some jurisdictions that's considered a building permit, you can demolish a building, you can do some grading, you can do some excavation, and maybe you have a building permit to do offsite improvements such as placement of utilities, sidewalks, right turn lanes on streets. If you haven't gotten a building permit to build your residential building, I'm sorry, that's not a vested right. The city can restrict the density, the number of units, or even altogether ban residential development in this particular zone because you have not yet pulled a building permit, even though you've done all this other amazing stuff. We don't care. You didn't get that your rights don't expand beyond the permits you already achieved. The owner of the undeveloped land under these refinements to the Avcor rule has no vested right in the existing zoning or more valuable zoning than anticipated or the highest and best use. An invalid permit vests no rights. It has to be a valid permit, right? So you can't rely, even if some planner says, don't worry about this permit if it's problematic, we're going to get you a new permit. It's going to be, you just give us time. It's going to take us 6 months to do that. The courts have said, look, if that planner or that city official had no authority, no express authority from above, from the decision makers, to make that statement, then there's no reasonable reliance on those statements, and we won't extend vesting to those statements made by the planner. The vested right may be limited or eliminated altogether if it would otherwise undermine public health or safety or would cause a public nuisance. And then open-ended of conditions of approval oftentimes have been interpreted to be imposed on that permit that would really take away from or diminish the right to build, right? So there are definitely, as you can see, serious flaws and limitations to this rule. And most of all, what developers lacked under this regime was lack of predictability, and therefore investment decisions really had to oftentimes be at great risk because of the holes in this vested right theory. So along comes the state legislature, says we need to fix this problem. Too many developers are at jeopardy. We're not seeing enough investment, especially in affordable housing. Let's try to find a way where we can provide greater certainty. The first step was to pass the vesting tentative map amendments to the Subdivision Map Act. And what does that mean? It means once you meet the conditions for the vesting parcel map, you have a so-called vesting date. There are two elements of protection, right? Let's first talk about what you have to do to qualify. Number one, you have to be in substantial compliance when the vesting parcel map is submitted with the various ordinance policies, et cetera, that are in effect at the time the application is complete. And that's typically doable. You don't have a right under this form of protection, against planning and zoning changes that the city initiates and publishes before your application is deemed complete. And we'll get to what that means in just a moment. But what are the rights that you get? The rights are twofold, as I mentioned. Number one, at the time that the application is either deemed complete by the city, or if the city fails to act within 30 days of receiving the application for the vesting parcel map, by operation of law, that application is deemed complete. So if the city does nothing, which it often does, it'll sit on applications for months on end, then the state law will take care of that problem by deeming that application complete. Why is a deemed complete so important? Because when that happens, that vesting date accrues. And that means that, again, any regulations, any restrictions, any moratoria that the city or the citizenry enact after that deemed complete date cannot apply to that project, even though the entitlements for that project are not going to be approved until some months or even years by the decision maker, be it a zoning administrator, be it a planning commission, be it a city council. So there's oftentimes, as you know, in California, many of you are aware, there's a lag time between an application submittal and the actual decision making. It can be 6 months, it can be a year, it can be 2 years, it can be 3 or more years. And during that lag time, any greater restrictions that are imposed cannot apply to that project. There's a huge benefit. And then what happens after the project is approved? By the way, getting that vesting deemed complete date doesn't guarantee that the city will approve the project. The city still has discretion to deny it if it's within the law to do so. But once the project is approved by the city council, what the vesting parcel map does is it continues that vested right period of time. You can develop the project in accordance with the project approvals for another period of time for the initial 2-year period of the vesting map. And if the city, at request upon the applicant, extends the vesting map in a discretionary manner, that vested right continues for all extensions of that map that follows thereafter, right? So here we go, which I mentioned all the protections here already. Let's see. And by the way, another important exception to the vesting rule for vesting parcel maps is that if the state or federal law requirements would otherwise impede or impose conditions on the property, the vesting parcel map protections do not extend to those state and federal law mandates. Okay. So, but cities continue to find ways around that vesting parcel map. And at the end of the day, the vesting rights under the map are limited because typically vesting maps are good for only 2 years after they've been approved. And then thereafter, they're subject to highly discretionary extensions of time. So that really only gave a 2-year window post-project approval for developers to have a vested right to make sure the rules are not changed. And a lot of these projects take a lot of time, especially if you have a multi-phase project or the projects are complicated or funding needs to be obtained. And that 2-year window of time may not be enough time. So what the legislature did was it passed the so-called development agreement law, where basically the state legislature told cities, city, you don't have to do this. Developer, you don't have to pursue this, but each of you can enter into a development agreement. And under this development agreement, you guys can negotiate, it's completely negotiable, a term under the development agreement. And during that term of the development agreement, vested rights are frozen, right? You get, let's say, 10-year, 20-year, 25-year, 30-year, I've negotiated as long as 35-year terms for the DA, during which time the city cannot change its rules. It can certainly change its rules, it can pass new legislation, but it cannot apply any later enacted regulations that are more restrictive or that would otherwise impede the rights to develop the project as approved for that 25-year period of time. So it took away that limited window that a vesting parcel map provides, right? What else? What are the other benefits of the development agreement? Under the DA, the developer can fold not just the rights that a vesting parcel map might otherwise provide, right? But let's say the city also requires a conditional use permit. Let's say the variances or other modifications of a city's development standards need to be obtained because the project requires it. There are height limits that the developer wants to exceed. There are design guidelines that the developer wants to be excused from, so he needs modifications. There may be a zone change or other legislative enactments. And so with the DA, the developer can negotiate with the city that any and all project approvals that I just described will be protected for that 25 or 30 or other term that you negotiate with the city. It's a huge benefit, right? It's enforceable as a contract. If the city for any reason violates or tries to violate that agreement by, for example, saying, hey, developer, we changed our minds. We don't want that huge monstrosity, 10-story multifamily residential development, especially if you're going to have 11% of them to be very low-income units. We're going to reduce density and cut your density by half. And tries to enforce that rule against the developer by, for example, not issuing building permits or not issuing a certificate of occupancy if it's already built. That developer can go to court and get specific performance or other injunctive relief to prohibit, or writ of mandamus to prohibit the city from trying to impose those later enacted restrictions. It's a legislative act. CEQA applies, of course, it's a discretionary action, and the city must go through that process to evaluate whether the project will generate significant impacts. It's a legislative act, so that means that the city must find that the project is consistent with the city's existing planning and other requirements. Now, interestingly enough, and this has been played out in the courts, oftentimes people who object to that project will say, wait a minute, you can't, city council, approve this project because your current zoning, your current planning regime does not allow this project as envisioned, because your developer is asking for an increase in heights, asking for all this modifications. And the city was found, yes, but among the approvals that I'm going to make with this approval of the development agreement is I'm going to change the zone. I'm going to make the modifications. I'm going to change the development standards so that under these legislative enactments, consistent with what the DA requires, by the time I approve the DA, all of the elements of this project will be consistent with our planning regime, because we will have made all necessary changes to make sure that happens. So that's usually a very good and a very effective workaround. The other amazing thing about the DA is it's also negotiable. The vesting date does not have to be the date that the city council approves the project and then signs it. The parties can apply a retroactive vesting date. So let's say developer in year one submits an application for all these entitlements, including an application for DA. By the time year 3 rolls around, the city council finally approves all the entitlements, including the DA. But in the DA, the parties have negotiated that the vesting rights retroactively apply to year 1, so that any interim restrictive measures, increases in impact fees, et cetera, that were enacted do not and cannot apply to that project. So that's sometimes cities will do that, other times they won't. It really depends upon how badly the city wants this project, and what kinds of community and other benefits that the developer will provide in this agreement, which we'll get into in just a minute. Bear in mind, however, that under this development agreement law, it is subject to referendum within 30 days of adoption. That is, if some stakeholders, members of the community, maybe even a competing developer, doesn't like this project, doesn't like this DA, it can seek to have a referendum pass in the city with the requisite number of voters to unravel the development agreement. And if the project is unpopular enough, that's a possibility. I've seen it happen. Fortunately, we've succeeded in avoiding referenda, or when they've happened, we were able to defeat them. But your client needs to be aware that the DA itself can be unraveled by a referendum. It has to be done within this 30-day period. It has to be the requisite number of voters, electors who sign it, and of course it falls upon the developer to run its own campaign to try to defeat the referendum if in fact it is submitted to the voters for approval. And then bear in mind, there's also a 90-day statute of limitations to challenge the development agreement law. Bear in mind, as many of you also know, though, there's even another shorter statute of limitations, a 30-day, typically 30-day or 35-day statute of limitations that applies under CEQA if there's going to be a CEQA challenge. Typically, if a project that has a DA is challenged in court, we will usually see both causes of action under CEQA and under the development agreement law, and of course, probably other laws as well. So that means, as a practical matter, these lawsuits, if they're going to happen, typically happen within 30 days. Although, if the challenger only limited its challenges to the DA-related mandates, it has up to 90 days after project approval to sue. All right, so what are some of the drafting considerations? I'll try to breeze through this, and I'm going to try to give you some examples of how to use this. So I mentioned earlier, what are the things, benefits, and what are the things that the city and developer will likely negotiate, and what the developer will certainly want. I mentioned the time period, purely negotiable. You can go 5. I have negotiated as little as, I think the lowest number I've negotiated was 10 years, and the largest number of years I've gotten for a term was 35 years, and everything in between. And again, it all depends upon how long of a period the city is willing, essentially, to waive its police power to have later enacted regulations apply to this project, and how complicated the project is. How many phases will it have? Will it depend on changing market considerations? So all these considerations are taken into account when negotiating the term. Extraordinary exactions. What do I mean by this? Well, one of the interesting things about this state law, many of you may know about the so-called Nolan and Dolan sort of nexus where you can, there's a taking of law if there's no proportionality between the condition imposed on the project and the need for that condition. So for example, if a project is going to build, is going to involve a multifamily and commercial retail center, and about a mile away, there's a veterans park and center that the city wants to see refurbished and redone, and wants the developer to pay for that. The developer says, wait a minute, you can't make me pay that. There's no nexus. This is a taking under constitutional law, and therefore you have to compensate me, or you can't impose that exaction because there's no reasonable relationship between my project that affects the local cause and this veterans park. My residents are not going to use that park. It's too far, and we're not going to create a need for it. The problem with the DA law, some see it as a problem, and the cities see it as a benefit, is that the California Supreme Court has carved out an exception to that nexus test, meaning that there need not be any nexus between any sort of community benefits that the state law requires. The state law says, developer, if you're going to get a development agreement, the city has the discretion to impose community benefits in exchange for getting all these amazing benefits under the law. And so oftentimes you'll see rather extraordinary community benefits, like, for example, the developer underwriting a major light rail station, funding park improvements, right? Providing for various community organization funding over periods of time, providing for infrastructure improvements that have nothing to do with the project's impacts and the like. There's the community benefits that cities require in California is limited only by the imaginations of planning and the city and fathers and mothers. So that's one of the things that one has to watch out for. That's very negotiable. And it really, really boils down to leveraging and who has the greater bargaining power here. Fee protection. You'll want to try as much as you can to freeze impact fees or other fees that the cities impose to either eliminate fees altogether, impact fees, or if the city's insisted on requiring fees, to trying to freeze, if you're representing the developer, any increases in fees during the duration of the term of the DA, or at least in doing them in certain stages. That is a very negotiable term. I've seen every manner of resolution of what kind of fee protection or not developer gets, but just bear in mind, you should definitely consider, if you're representing a developer, protecting your client from increases in fees that could occur over time. They typically increase annually for many of these cities, or every 5 years. And they can really, really be tremendous costs to the project's overall expense. You can amend the DA, but they typically require notice and findings, and oftentimes an amendment really involves a very similar process, legislative and ordinance making process, as the original DA. So bear that in mind. It does involve some procedure. What we do to address that concern is we'll try to build in an envelope. Usually it's a 5 or 10% of increase in, for example, development's density and other elements. We try to build in some ability for amendment or what we call modification, with that wouldn't require an amendment, that the city planner or the city manager would be delegated the authority to approve, right? So we try to provide standards, and courts have upheld those standards so long as they really don't amount to a true amendment to the DA. Just bear in mind that any future approvals to improvements, you may get entitlements at the outset, a handful of entitlements, but down the road, for example, especially if you have a multi-phase project, you may need other approvals. You may need site plan review. You may need to see design guideline review. You may need any number of other discretionary actions. Bear in mind, those future discretionary actions will require secret review. What we try to bake into both the entitlement process and into the terms of the DA is a secret review that tries to reasonably anticipate any and all future approvals and future design elements of the project, even if the developer may never, for example, provide for a fourplex cinema, or for a 50,000 square foot Whole Foods store, or for a gymnasium that's going to require 15 or 20 extra parking spaces you otherwise might need. Even if your future phasing or future project elements may not include this, we often advise clients, include those in your project description, include those in your CEQA review, so that as and when future approvals are going to be needed for those project elements, you've already complied with CEQA, and we negotiate and bake into the DA that the city shall not require any further CEQA review other than a notice of determination that we've already done this analysis to the extent permitted by law. I mean, obviously you can't negotiate away what state law requires, as I mentioned earlier, for vesting maps under the DA process. There's a carve out that you cannot vest against changes in state and federal law. State and federal law requirements are exempt, but we do try to limit future CEQA review so we can limit any future entitlement and CEQA risk in the event that you need future discretionary actions to effectuate future phasing of the project. We also try to define the future regulations that the city cannot apply to restrict the project's development anyway. For example, building permit fees. Even things like the proceedings, if the city starts adding layers of approval, well, not only does your project require planning commission approval for, let's say, an amendment to your CUP, but we also have to have the zoning administrator initially review. Then there's a right of appeal to the planning commission. We're going to add another procedural hurdle. It's going to go up to the city council hearing. We try to bake into the future, the sort of menu of future legislative and discretionary, administrative discretionary actions that the city can impose by saying these are the kinds of things that you cannot do in the future. And how that looks, the length or shortness of that menu of restrictions really depends again on bargaining leverage. We also try to include, and usually succeed in including, some form of streamlined review of future project approvals so that that process is much more effective and less time consuming and less risky for our clients to proceed with. And as I mentioned at the outset of this discussion of DAs, you can include all your entitlements within the scope and term of vesting. So for example, if you also happen to have a vesting parcel map and your vesting parcel map is going to expire 2 years after, otherwise would expire 2 years after your project approval, if you fold that vesting parcel map within the scope of your DA, guess what? That vesting parcel map is not going to expire for another 20, 25, 30 years, however long your DA term is. So that's a very, very powerful advantage and benefit that the DA provides. Okay, so I mentioned community benefits. That's the quid pro quo that the cities have. Basically, as I mentioned, the city can provide all manner of benefits that we mentioned. I give you some examples. And we talked about some of the risks involved. There's no nexus or rough proportionality. It establishes a precedent for future benefits, both for your client's project and other projects. And the DA could still be challenged by a community group that feels that those community benefits are not enough. So you have to be careful because then it becomes a public forum. The thing to keep in mind, and I've seen a few projects successfully challenged, is that developers often don't take into account that whatever community benefits they agree to fund or build or undertake must be included within the scope of the project description. So for example, if all the developer intends to build is a 400-unit mixed-use residential commercial retail project with this 11% set aside for very low-income housing units, and the city says, that's great, but I want you to, again, improve that Veterans Park that I have 2 miles from your park. I want you to refurbish, upgrade my community center. I want you to build me new baseball stadiums, and I want you to add a gymnasium and a swimming pool to this park. And the developer says, okay, I can do this with all the benefits that I have here. I'll do that. And guess what? The project description doesn't include all those improvements to the Veterans Park. They're not included in the project description. There's no impact analysis that evaluates what kind of environmental impact, if any, would that new gymnasium cause? Would that expansion of the community center generate? With the swimming pool addition? With the improvements to the parking fields? How many more traffic trip generation would there be as a result of those improvements to the park? If none of that is included in the project description, even though it's simply a function of the community benefits of your development project, and even though the developer never intended to fund initially when the discussion started out, fund those improvements to that park, then that project becomes vulnerable to a legal challenge in a CEQA proceeding, because petitioner will say rightly, hey, Your Honor, the city did not appropriately consider all aspects of this project. And since the community benefits requires the developer to do these improvements, those improvements should have been included. The park improvements should have been included as a part of the process. So just have to tread very, very carefully. Okay, here's a comparison of vested rights. I'll run through it really quickly because I want to just try to finish within my allotted hour. I'm almost there. You can quickly go through that and do the comparison. We've already gone over each of these, but this is a nice way to compare and contrast. And as I mentioned, I advise in virtually every project now that I have where I advise clients to do a development agreement because, and by the way, development agreement makes sense when the project itself is going to be designed, developed, and built over a significant period of time. Because again, time is typically not the developer's ally because it gives time, the more time the city has, for both the city and for residents to try to find ways to limit or restrict development, especially if the city is experiencing intensive development activity. So I bring this up because what we say to clients is, if your project's going to involve any kind of subdivision, I would say combine, get a vesting tentative parcel map. So you have your vesting date that starts at the very beginning of the process. And get a DA where you can essentially include that vesting parcel map protection with your DA. But so this comparison then becomes academic. But if you're going to do just one or the other, you can see what the relative benefits are and burdens of these two different processes. So let's see, I have about 5 minutes. Maybe I should ask if there are any questions now. I can expand a bit upon what I just said, but let me know if you have any questions. Otherwise, I can elaborate a little bit more on those benefits and burdens. Angela, do we have any questions? If not, I can continue with this discussion.
If you could go through the benefits and burdens, I think that would be fantastic.
Okay, sure. Very good. So I was afraid that I would use up all the time without any questions, time for questions. So vesting tentative maps, as I mentioned earlier, there's a mandatory processing that you have to go through. Again, a DA is something that you don't, that's completely up to the developer and the city. The city doesn't have to do it, and the developer doesn't have to do it. Now, there's been an interesting phenomenon that's occurring in more and more cities in California, and that is, especially in those cities that are facing budgetary shortfalls. This definitely happened during the Great Recession, and we're seeing it recur again during the pandemic, where cities are seeing their infrastructure, their street infrastructure, their schools, their police and fire departments starting to decay, starting to reduce in service because there's just not enough tax revenue. So what's happening now is cities are passing ordinances, passing laws that require developers to enter into development agreements. And you might wonder, why would a city require the developer to do something that would give an extraordinary benefits to the developer? Because if a developer has to enter into development agreement, guess what, for say a multifamily project, why then the developer must provide community benefits. And when it comes to community benefits, it's the city that usually dictates what those community benefits are. So basically, you're holding the developer hostage to those community benefits because the developer doesn't want a development agreement because the developer knows that it's going to have to provide community benefits. It doesn't need a development agreement, but in some cities, the city does not give the developer a choice. Now, I predict, or I suspect at some point or another, some developer in some city is going to sue the city and say, wait a minute, you now, because you're making this, it's no longer an arm's length negotiation. This is not just some contract that each side voluntarily, under no duress, enters into. You now put a land use gun to my head and are compelling me to enter into this development agreement. And because it's compulsory, then you have to show a nexus. Any community benefit that you would otherwise seek to impose on me through this DA process and not through your codes, which don't provide those benefits, you now, city, have to show a nexus. You have to show that all those improvements you want me to make to that Veteran Center 2 miles away somehow are necessitated by the impacts, the traffic or other impacts my project's going to generate. And if you can't show that nexus, then you cannot make me enter into a development agreement, or at least you cannot make me pay for that community benefit. And I think the reason why there's some possibility a plaintiff or petitioner would succeed is because of the compulsory nature of the DA. This is effectively a code requirement. If it's a code requirement, there has to be a nexus between the two, the cause and the effect, the community benefits and the project's causes. So anyway, just food for thought there. As I mentioned, the vesting tentative parcel map, the exactions, the conditions, typically the cities will have all manner of conditions relating to ingress, egress, infrastructure requirements, access to all lots, making sure that every lot that's subdivided and created, there has to be some sort of public infrastructure, street access. Under the DA regime, all the exactions, as I mentioned, are negotiable. There's nothing that's required, unless, of course, as I mentioned, in the case where the cities may have a mandatory DA requirement. The other entitlements are discretionary. The vesting tenant parcel map has to be given once you establish, as I mentioned, and you have a vesting date. And in the DA, the agency may agree to future entitlements, right? As we talked about before, that's entirely subject to negotiation. The vesting tenant parcel map, as I mentioned, you have a vesting date that occurs at the time that the application is deemed complete, either by the city or by operational law if the city doesn't respond to the application within 30 days. In the DA, the vesting date is completely negotiable. It can be retroactive. It can be the date when the city council approves it and signs it, or it can be a prospective, right, as a prospective date. Under the vesting tentative parcel map, there's a 2-year period of time for the vesting period. And as I mentioned under DA, that term is as long as the parties can negotiate, long or short as the parties decide to negotiate. Let's see, and then the vesting tentative map does not limit other agencies. It does not limit the other agencies under DA if they're not a party to the DA. The vesting tentative parcel map, unlike a DA, is not subject to a referendum. Under a vesting tentative parcel map, there are local procedures required, and local procedures can be imposed if requested. As I mentioned, both of them have 90-day statute of limitations, but as a practical matter, because of CEQA, typically we see challenges brought within 30 days that also challenge any claims they might have of a vesting parcel map and a DA. And as I mentioned at the outset, you can actually mix and match these various tools that you have under state law to entitle a project where you can provide affordable housing. So for example, if you want to have a vesting date that starts out at the very start of your application process, even before 30 days an application is complete, you file an application under the Housing Accountability Act, because at the end of the day, when all is said and done, except for the density bonus law and some of the other entitlements that you might be entitled, they would be consistent with the city's planning and zoning laws. And if that's the case, the city has to approve your project, right? And you have your vesting date from the moment that you file the application. You don't have to wait till the application for the vesting parcel map is deemed complete, which can happen many months after that because it takes time to put those applications together. And you don't have to wait till 2 or 3 years later when the city council adopts a DA. And so you freeze the vesting date for that period of time. And the developer would claim, I'm compliant with all the city code requirements because even though I'm getting incentives under the density bonus law, guess what? Your local ordinance requires compliance with that density bonus law. So therefore, because I am seeking incentives and a density bonus under state law and local ordinance that authorizes this, I am completely compliant with your regulations. So taken together, they can give you an early vesting date, they can give you density bonuses, they can give you incentives, and they can protect your rights for as long as you can negotiate that agreement. And now I think my time truly is up. Angela.
We do have a few questions for you, Fernando.
Okay.
So although under the density bonus law, you mentioned that incentives and concessions are at the developer's election, as a practical matter, in your experience, which incentives or concessions have cities been most receptive to and which have they been most resistant to?
Well, that's a great question. In the real world, and I have to tell you, it really depends upon the city. We have seen typically smaller cities don't like height, and don't like setback elimination. They tend to give on parking. They'll even give greater parking incentives than, say, what the state density bonus law might provide. They might give on floor area ratio for example, if you're going to include commercial office or retail. Cities really like large and small, really like retail. So they may give on design guideline requirements for commercial retail space. They might give on FAR, they might give on parking, but they don't like height. They don't like massing, large massing and scalability, where you've got what they view as a big bulky building and an otherwise relatively quiet, low density, low height communities. And so that's where typically it's height, it's massing, and the setback requirements of cities are resistant. Most cities that we've dealt with ultimately come around because they realize the law's not on their side. A few cities have resisted and pushed back and say, instead of asking for height, why don't you ask for FAR, or why don't you just reduce your density and we'll give you other incentives, we'll give you other protections, we'll streamline your entitlements, et cetera. But it really varies from city to city. I wish I could give you a general rule of thumb. Some cities don't care. They'll give you whatever incentives and waivers you want because they really, really want to see that project. Other cities I've had to threaten to sue and ultimately did sue until they finally relented and gave us the incentives that we were otherwise entitled to. I hope that answers your question.
Yes. I think your slide, I believe, noted that the Housing Crisis Act of 2019, it seems to expire in 2025. Do you have a sense of whether or not the legislature is likely to extend or renew the provisions of the act? And does that expiration date give you any pause as you're counseling clients?
Not really. I have speculation as to the first question, and no, generally, I don't think it gives any of our clients pause. So let's start with the first question. It's hard to tell whether the legislature will have an appetite to extend at the time of sunsetting. My own prediction is that some form of this law will in fact be extended, and the reason being, I just don't see, especially, and I'm being perhaps the hopeless, or depending on your perspective, hopeful optimist, that with this pandemic explosion in our economy, that I think is going to carry over for the next 2 or 3 years, the demand for housing is only going to increase, and the demand for affordable housing in particular will skyrocket. It's already pretty high now, will skyrocket. That's because our economy in California is going to do so well. It's already picking up enormously. With any increase in jobs, the jobs market, any improvement in the economy of the scale that we're seeing now, typically the demand for housing is enormous, and residual land values, as horrible as they are now, will only get worse. And that means the state has to find ways to incentivize developers to provide for affordable housing when all their other costs are so extraordinarily high. So I think all of the economic considerations that drove the legislature to enact this law in the first place in 2019 will only become magnified by the time 2025 rolls around. I could be wrong. And if I'm wrong, I hope you don't remember my making this prediction, but that's what I think is going to happen. And then as to pausing, I'm sorry, as to pausing, no, I wouldn't say that, because most of the time between now and 2025, what happens is you're going to have your project deemed complete, your application investigated deemed complete. So even let's say you do this in year 4, 2024, your application is deemed complete before expiration of 2025. Guess what? Even though the law expires, you were deemed complete under that law before it expired. And the changes that happen thereafter would not apply to your client's project. Now, has that been litigated and resolved in the courts? No, but the way the statute's written, I think you really have a good chance of locking in your rights, so long as you get your applications deemed complete before they expire. Sorry, Angela.
No, thank you. Under the development agreement laws, with the purpose of the development agreements being to ensure those vested rights, are there any issues relating to passing on those rights to successors that we should be aware of, or that you've come across?
That's a great question. And as I promised at the outset of this conversation, I would try to keep it at a high level, but now we're getting a little bit into the weeds, and these are really, really important weeds. That's a great question. And we deal with this issue time and again. Generally speaking, the rights under a development agreement can be transferred to a successor owner. So let's say I'll give you one scenario that actually transpired. We had a client that acquired about, I want to say 4 acres out of about 110 acre master plan, a mixed use, commercial, retail, residential, entertainment planning community in the San Diego area. And we only wanted a sliver of the rights in the development agreement. Fortunately for us, and for our client, the developer and its counsel crafted terms, which you can craft. State law authorizes this to happen. We crafted the master developer crafted terms in the master DA that allowed an assignment of interest in the DA in whole or in part. Subject to the, generally speaking, you will find in virtually every DA I've seen where we have, and I always try to negotiate assignability and transferability rights. You will find where you get those assignability and transferability rights, cities will also want a right of approval, usually not to be unreasonably withheld, is what I negotiate, where the city wants to make sure that any assignee, any transferee of those development rights will have the financial wherewithal, has a proven track record of being able to underwrite and build a project, right? And so in our case, we had a national multifamily apartment developer that had a great reputation throughout the country, and especially in the San Diego area. And our client received approval by the city of San Diego to transfer those rights to our client, and that was done. And again, that's a very negotiable term. I strongly recommend that your clients consider that and include that in your DA. You never know when a client may want to walk from a project or may find it economically or otherwise desirable to do so. Having those assignable and transferable rights hugely, we've seen increases the marketability, the value of that property.
And one final question for you, Fernando. You mentioned that amendments to development agreements will trigger notice findings and so forth. In practice, where is the line between a modification and a full formal amendment to a DA that's going to trigger that notice and findings?
That's a great question. And I don't know that there's a fine or I should say clear, bright line, but usually it's where, for example, you're going to change the project itself. Let's say we entitled an 800 unit, 50,000 square foot commercial retail entertainment facility and a community center for the city. It's all in one project. We actually have a project like that. And we get the entitlements, we get the DA, and 3 years down the road, our client says, something, I really want to have another 50 units, and this I want to be for sale townhome product, and I really want that. I want to bring it under my DA, Fernando. Can you help me here? So, something, you're changing the project and you're changing the improvements. It's not simply a iteration of, or maybe a refinement of your project. It's a different project. 50 new townhomes for sale that have a different footprint. That's going to have its own standalone building. It'll have its own additional parking requirements. That's somewhat of a different project. That would most likely require an amendment, right? And that's when you have to go through that legislative process of notice. It's essentially the same procedure that the city council had to follow to approve the original underlying DA. Other circumstances that wouldn't require an amendment would be such things as, for example, our client decides, something, I instead of having 800 residential units, I really only want to have 750 units, and I'd like to use that FAR or that unit count or whatever to add to my my retail space and entertainment space. I want to add another 5,000 to 10,000 square feet of retail. I would say arguably that's a refinement of the original project. You may have to either reduce or increase parking by a little bit, and secret, by the way, is a big driver determining what's a refinement and what requires an amendment. And in that situation, what we try to do is craft terms of the DA that says, hey, if any revisions or approvals to this future approvals for the project would not increase the density or decrease the density, for that matter, by more than 5% of the total square footage, and would not generate any more traffic trips than the total aggregate traffic generation that the EIR for this project under CEQA projected, then the city manager shall be delegated the authority to review and approve any and all such modifications. And it has to be noticed to the city council and other things, but there's no public hearing, there's no hearing before the city council. That would not require an ordinance, etc. I'm sorry to say there's no bright line, but usually it's the rule of reason, it's common sense. And oftentimes the city itself will establish standards.
Well, thank you so much, Fernando. Your presentation has been fantastic, and we appreciate that you've been so generous with your time.
You're very welcome. It's been a pleasure. Thank you all for showing up and for listening and bearing with this presentation. I hope you found it useful. I hope that your clients can benefit from some of the things that we presented. If you ever have any questions, you want to have a dialogue thereafter, by all means, feel free to contact me. And Angela and Ann, thank you very much for having us as a presenter. Very much enjoyed it.